Today's video focuses on the proposed changes to ICSID's rules for the conciliation of investment disputes.
Overall, the proposals seek to clarify and simplify the conciliation process. General administrative provisions are grouped together and include provisions on confidentiality. The without prejudice clauses have been enhanced to alleviate any concern that information shared during the conciliation will prejudice later arbitration proceedings. For example, unless the disputing parties agree otherwise, neither party may rely on statements, admissions, or offers of settlement made during the conciliation process in any other proceeding.
A few new provisions have been added, namely that the Secretary General may assist the parties with the appointment of conciliators. In the absence of an agreement by the parties on the constitution of the Commission within 60 days of registration, the default provision requiring a 3-member commission automatically applies.
Conciliators are required to provide a more comprehensive declaration of impartiality and independence. In addition, the revised rules require that a conciliator not act in any other capacity in any other proceeding related to this dispute unless the parties and the conciliator agree otherwise.
Changes have also been made to the process of disqualification of conciliators. The rules now contain specific deadlines for the filing of conciliator challenges and for the parties and the conciliator's observations. It is also proposed that the conciliation may continue while the challenge is pending.
The conciliation process begins with each party filing a written statement within 30 days of the Commission's constitution. These statements should contain the parties' views on the disputed issues and the parties' views on the procedure. The Commission will then hold a first session to address procedural matters and begin the conciliation process.
Throughout the process, the role of the Commission is to clarify the issues in dispute and assist the parties in reaching a mutually acceptable resolution of all or part of the dispute. The Commission may request that the parties provide additional information, explanations, or documents. It may conduct a site visit with the parties' consent and may meet or communicate with the parties jointly or separately.
After consulting with the parties, the Commission may also make recommendations containing specific terms of settlement or recommend that the parties refrain from taking any steps that might aggravate the dispute.
Before the constitution of the Commission, a conciliation proceeding may be terminated by party agreement or for the party's failure to act. After the Commission's constitution, the conciliation terminates with the issuance of a report by the Commission.
If the parties reach agreement during the conciliation, the revised rules propose that the report may contain the complete and signed settlement. This amendment ensures that the report conforms to the requirements established by the draft Singapore Convention, which will open for signature in 2019, and will assist the parties in ensuring implementation of their agreement under the Convention.
We hope you have found this brief overview useful. For more information, visit ICSID's Rule Amendment website, which is available in English, French, and Spanish.